They didn't warn her. They didn't ask questions. They put handcuffs on my daughter for jogging on a public street, and the moment cold metal closed around her wrists, something precise and irreversible took over inside me. HOA Karen stood there claiming community standards while using borrowed authority to publicly humiliate a 16-year-old girl. I didn't shout. I didn't plead. I walked forward with the kind of certainty that tells everyone watching control has already changed hands. My daughter's eyes met mine, and, even shaking, she stayed upright. Neighbors watched from porches in the trained silence of people who have learned punishment follows objection. I understood two things immediately. Those cuffs were coming off, and the HOA that enabled this would not survive what came next. Before we move forward, drop a comment. Where are you watching from? The officers wouldn't meet my eyes, which told me everything about how confident they actually were in what they were doing. This wasn't law enforcement acting on law. It was compliance theater performed for a woman who mistakes intimidation for purpose. HOA. Karen crossed her arms like a principal waiting for an apology, convinced she was untouchable because uniforms and bylaws stood near her. She believed she had security, police cooperation, and procedural cover on her side. She didn't realize she had just placed herself directly in front of someone who understands jurisdiction, evidence, and consequences as daily tools. I asked one question, quietly, without emotion, because emotion is wasted on people who hide behind process. What is the charge? The answer was a string of buzzwords stitched together to protect an ego. Loitering, trespass, failure to comply with a private directive. None of it applied, none of it held, and all of it was being used to justify chains on a child who had been jogging. Karen smirked like this was the end of the story, like the street itself was the courtroom, and fear was the verdict. I leaned close enough to my daughter that she could hear me without anyone else needing to, and I told her to breathe because this would be over soon. The street wasn't my battleground, and I wasn't going to argue where posturing thrives. Courtrooms are where lies die, statutes replace tone, and authority has to prove itself line by line. HOA Karen didn't understand that yet, and that ignorance was her greatest liability. She saw handcuffs as a warning to the neighborhood, proof that resistance ends in humiliation. I saw them as evidence preserved in daylight, on camera, in front of witnesses who would remember exactly how eager she was. Every order barked, every nod she gave, every second she enjoyed the spectacle added weight to what would follow. When the cruiser door closed and my daughter was driven away, the street went unnaturally quiet. I didn't threaten anyone, because threats are unnecessary when the law is already turning. I stood still and let the silence harden into resolve, knowing the HOA had just crossed a line it could never uncross. I didn't arrive at that street unprepared for what power looks like when it's misused, and HOA Karen's confidence wasn't new to me. It was familiar in the way bad habits always are. I've spent years watching people confuse proximity to authority with authority itself, learning how quickly borrowed power collapses when it's asked to justify its own behavior. That history mattered in that moment, because while she believed the presence of uniforms meant legitimacy, I knew legitimacy only exists where law, cause, and restraint intersect. Everything else is theater, and theater falls apart the moment it's recorded, examined, and slowed down. My daughter knew that, too, even if she couldn't have articulated it in legal terms. She grew up watching me handle disputes not with volume, but with preparation, not with threats, but with timelines and filings. She understood that calm isn't weakness, and silence isn't surrender, and that knowledge steadied her when strangers stared, and an HOA president smiled like she'd won something. That composure didn't come from bravado. It came from trust, the kind that forms when a child knows the person standing between them, and harm doesn't miss details, and doesn't forget names. HOA. Karen misread that silence the way she misread everything else. She assumed restraint meant fear, and that walking away meant backing down. In her world, people who don't fight publicly are people who can be managed privately, fined quietly, and pressured until they comply. She had built her reputation on that misunderstanding, collecting small victories over neighbors who didn't have the time, resources, or appetite to push back. That strategy works until it doesn't, and it stops working the moment it's aimed at someone who understands how venue decides outcomes. The street was designed for her advantage, not mine. On the street, uniforms intimidate, crowds hesitate, and authority can be implied without proof. In court, implication dies quickly. In court, every action needs a statute, every order needs jurisdiction, and every justification needs to survive cross-examination. HOA Karen thought she had won because she controlled the immediate scene, but she never asked herself what would happen once that scene was transferred somewhere she couldn't control with tone and posture. My authority didn't come from rank or volume. It came from familiarity with process and a refusal to be rushed into the wrong arena. I didn't challenge the officers because I didn't need to. Their uncertainty was already visible, their discomfort already recorded. I didn't confront Karen because confrontation is a distraction when the real work happens later, under oath, with consequences that don't evaporate overnight. She thought the story ended when the cruiser drove away. I knew that was when it finally began. On the drive home, with the street already receding behind me, I didn't replay the scene for anger's sake. I replayed it for sequence, cataloging movements, words, timings, and reactions. Who spoke first? Who hesitated? Who nodded? Who avoided eye contact? Abuse of power leaves patterns, and patterns become arguments when you know how to present them. Karen had given me everything I needed, not because she was careless, but because she believed no one would ever force her to explain herself in the right room. That night, as the house settled into an uneasy quiet, I understood exactly how this would unfold. There would be no shouting matches, no dramatic confrontations, no attempts to shame her into apology. Apologies don't dismantle systems, and shame doesn't undo damage. What undoes both is exposure paired with consequence, delivered through procedures that don't bend to confidence. HOA Karen had spent years relying on people not knowing where to push. By detaining my daughter for jogging, she had shown me exactly where to apply pressure. The decision to move forward didn't feel righteous or vengeful. It felt procedural, like flipping a switch that had always been there. Karen believed authority flowed downward from titles and committees. I knew it flowed outward from accountability, and the moment she put handcuffs on my child without lawful cause, she turned accountability from an abstract risk into an immediate certainty she could no longer outrun. HOA Karen didn't invent her power on the spot. She inherited it from a structure designed to reward people who speak confidently and rarely get challenged. Homeowners associations thrive on the quiet agreement that enforcement is someone else's problem, that fines and letters and warnings are inconveniences best endured rather than confronted. Karen learned early that most people comply not because they agree, but because they are tired, busy, or afraid of escalation. She wrapped that reality in procedural language and sold it as order, and for a long time, no one questioned how thin that order actually was. The board around her functioned less like oversight and more like insulation. Meetings happened, votes were taken, minutes were filed, but none of it was designed to stop her from acting, only to make her actions look collective after the fact. Responsibility blurred by design. When a decision hurt someone, it wasn't Karen's choice, it was the board's. When the board was questioned, it was policy. When policy was challenged, it was interpretation. That diffusion of blame created a comfort zone where Karen could push further each time, confident that the structure would absorb the shock. Selective enforcement was her most reliable tool. Rules existed for everyone, but consequences arrived only for people who didn't fit, people who asked questions, people who lived differently, or people who were simply inconvenient. Jogging became loitering, standing became trespass, silence became non-compliance. Karen didn't need the rules to make sense. She only needed them to sound official long enough to intimidate someone into backing down. Most did. They paid the fine, removed the flag, changed the routine, and learned the lesson she wanted them to learn. Police involvement added a layer of intimidation that made her feel untouchable. She learned quickly how to frame complaints in a way that invited response without scrutiny. using language that triggered action while avoiding specifics that might fall apart later. Officers arrived expecting cooperation, not conflict, and Karen positioned herself as the reasonable authority maintaining peace. That dynamic shifted power instantly, not because she was right, but because uniforms create hesitation. She mistook that hesitation for endorsement. Neighbors saw it happen again and again, and silence became the safest response. People stopped jogging certain routes, stopped sitting on their own porches, stopped questioning notices taped to their doors, not because they believed Karen was right, but because fighting felt expensive and uncertain. Fear doesn't need to be loud to be effective, it just needs to be consistent. Karen was consistent. She didn't explode, she applied pressure steadily, and the structure around her protected her from having to justify it. What she never accounted for was the difference between authority that persists because no one challenges it and authority that survives challenge. Her power had never been tested in a setting where documentation mattered more than demeanor. It had never been slowed down, replayed, and dissected by people who don't care how confident she sounds. Detaining my daughter wasn't just an abuse, it was an overreach that stripped away the ambiguity she relied on. Jogging is not a gray area. Handcuffing a minor without cause is not open to interpretation. By turning a mundane activity into a spectacle of force, Karen exposed the core truth of her system. It wasn't about safety or standards, it was about control, exercised through fear and shielded by procedure. The board that once insulated her would soon discover that insulation works both ways, and the policies she hid behind would become evidence instead of protection. She believed the HOA structure made her powerful. In reality, it made her visible, and visibility is the one thing abuse cannot survive for long. Once the street was behind me and the noise of flashing lights and whispered speculation faded, everything narrowed into process. Outrage is loud, but temporary, and it burns itself out if you let it run the show. Proof, on the other hand, compounds. It grows heavier the more carefully you stack it, and I knew from experience that the only way to dismantle a system like Karen's was to let its own records testify against it. She believed her authority lived in moments, in the immediate compliance she could extract with posture and tone. I knew authority that lasts lives on paper, in timestamps, footage, and sworn statements that don't forget what happened once adrenaline wears off. The first document I pulled wasn't dramatic, and that was intentional. Incident reports are where overreach hides behind adjectives, and hers was exactly what I expected. It was padded with phrases like felt threatened and refused to comply, language that signals justification rather than description. There was no clear statute cited, no objective behavior that explained why handcuffs were necessary, just implication piled on implication. Each vague sentence was a gift. Vague language collapses when it's forced to answer specific questions, and I marked every place where emotion replaced cause, every spot where authority was assumed instead of demonstrated. Body camera footage arrived next, and I treated it the way I treat all evidence, without drama and without rushing. I watched it once straight through to understand flow, then again slowed down to catch what people think disappears between frames. What stood out wasn't just what the officers said, but how often they looked toward HOA Karen before acting. Direction doesn't need to be verbal to be clear. A nod, a step forward, a glance seeking approval tells a story no report can erase. Karen wasn't a bystander in that footage. She was present, engaged, and visibly satisfied as the situation escalated around a child who posed no threat to anyone. Audio matters as much as video, and the soundtrack of that encounter was uncertain. My daughter's voice was steady, asking simple questions, while commands directed at her wavered and shifted. That imbalance matters. Lawful authority doesn't wobble when it explains itself, and unlawful authority fills gaps with volume and repetition. Karen's voice cut in at key moments, framing jogging as defiance, presence as provocation. She wasn't enforcing rules. She was narrating a story she wanted officers to believe, and they followed it because it was easier than challenging her in the moment. From there, the scope widened. I pulled the HOA bylaws not to argue their validity, but to establish their limits. No provision gave Karen the power to detain, restrain, or direct police to arrest someone for exercising a normal activity on a public street. That absence was critical. Abuse of power isn't just about what someone does, it's about what they pretend authorizes them to do it. Karen had crossed from enforcement into impersonation, and the gap between those two things is where liability lives. I gathered witness statements next, not because they were necessary to prove what the footage already showed, but because patterns matter. Neighbors described the same tone, the same language, the same escalation tactics they'd seen used before. Minor issues inflated into confrontations, always framed as community protection, always ending with someone backing down rather than pushing back. My daughter's detention wasn't an anomaly. It was the clearest example of a behavior Karen had refined over time. When isolated, each incident looked small. Together, they formed a map. Insurance and liability entered the picture soon after, because that's where consequences become unavoidable. Boards and officers can posture all they want, but insurers don't care about confidence or rhetoric. They care about exposure. The moment footage and reports were paired with statutes and timelines, the question stopped being whether Karen had acted improperly and became how much her actions would cost everyone who enabled her. That shift is always quiet, but it's decisive. Systems begin correcting themselves once the financial risk becomes real. By the time I finished assembling the file, there was nothing speculative left in it. Every claim was anchored to evidence, every conclusion tied to a statute or precedent. Karen believed her power came from being seen as decisive. What she never understood was that decisiveness without legality is just speed on the way to accountability. Detaining my daughter for jogging didn't just reveal her overreach, it documented it in a way that could not be reframed or softened later. The proof didn't argue. It waited, complete and patient, for the moment it would be placed in a courtroom where confidence means nothing without law to support it. The courthouse never announces when momentum shifts. It just allows it, and that morning the building felt like it was waiting for something inevitable to arrive. HOA. Karen walked in carrying herself the way people do when they've rehearsed victory. Posture straight, smile measured, surrounded by board members who mistook proximity for safety. She believed the setting favored her because she had spoken in rooms like this before, because she knew how to sound reasonable, because she had never been forced to defend her actions under the kind of scrutiny that doesn't blink. She thought this was another meeting, another chance to explain away behavior with tone and selective memory. I didn't rush to confront her. I took my seat and watched the performance unfold because collapse is more complete when it's built on its own confidence. Karen spoke when called, leaning into familiar phrases about order, safety, and expectations, presenting herself as a reluctant enforcer burdened by responsibility. She framed my daughter's detention as an unfortunate necessity, a response to perceived non-compliance, carefully avoiding specifics that would anchor her story to reality. Her attorney guided her gently, smoothing over rough edges, reinforcing the illusion that this was still a narrative contest rather than an evidentiary one. What Karen didn't see was the way the room reacted, not emotionally, but procedurally. Judges don't respond to posture, they respond to contradictions. Each time she spoke in generalities, the silence that followed grew heavier. When specifics were requested, her answers thinned. Confidence without clarity has a sound to it, a hollow echo that professionals recognize immediately. The board members seated behind her shifted as that sound became harder to ignore, each movement a small attempt to create distance from a story that was no longer holding together. The turning point didn't come with raised voices or dramatic objections. It came in the hallway during recess, where control can't be maintained by microphones and seating charts. Karen was laughing, the tension she thought she'd navigated behind her, when I spoke her name. Not loudly, not sharply, just enough to require her attention. She turned with irritation already prepared, expecting another resident seeking acknowledgement. I gave her my name, nothing more, and watched as recognition moved across her attorney's face before it reached hers. That moment didn't explode, it contracted. Her lawyer's posture changed first, shoulders tightening, eyes scanning for exits that didn't exist. Karen followed his gaze back to me, and the confidence she'd been wearing began to fracture. I didn't threaten her or accuse her. I explained calmly and publicly what had already begun. I named statutes, outlined exposure, described the preservation orders already in place. I made it clear that this was no longer a dispute, but an inquiry, and that every decision she had made would be reviewed by people who don't accept explanations without evidence. The hallway grew quiet, not because people were shocked, but because they understood what silence meant in that context. Board members stepped back without realizing it, the instinctive response of people who sense liability becoming contagious. Karen tried to reassert herself, to frame the situation as misunderstanding, but words that once worked in HOA meetings fell flat here. There was no audience for indignation, no appetite for justification. Her authority had depended on controlling the narrative. That control was gone. When proceedings resumed, the shift was unmistakable. Questions sharpened, timelines narrowed. Her earlier testimony was revisited, not with hostility, but with precision that left no room to maneuver. Each inconsistency was noted, each omission highlighted. The board's role came under scrutiny, and with it the policies Karen had hidden behind. The structure that once diffused responsibility now concentrated it, and every path led back to her decisions. The collapse wasn't loud. It was methodical. Subpoenas were referenced, documents requested, and the tone of the room changed from discussion to accounting. Karen's voice grew smaller as she realized she was no longer steering the process. The board members avoided her eyes, already calculating what separation would cost less than loyalty. By the time the session ended, nothing had been decided publicly, but everything that mattered had shifted. Karen walked out without the entourage she'd arrived with, her confidence replaced by something unfamiliar and deeply uncomfortable. The confrontation she thought she could manage had turned into exposure. She could not escape, and the public collapse had begun not with a verdict, but with the quiet understanding that her authority had finally been placed somewhere it could not survive. Karen's response to losing control was not reflection, it was retaliation, and that reaction told me everything I needed to know about how deeply she misunderstood what had already happened. People who rely on intimidation don't suddenly become cooperative when pressure is applied. They lash out with the only tools they've ever trusted. She filed complaints, sent emails, and tried to reframe the narrative as persecution rather than accountability, assuming volume and persistence could still bend the situation back in her favor. What she didn't understand was that once the process shifts into expert hands, retaliation only tightens the net. Every move she made after that hallway confrontation generated more documentation, not relief. Attempts to justify her actions created timelines that contradicted earlier statements. Efforts to rally board members exposed internal disagreements and private communications that should never have existed. Her insistence on framing herself as a protector invited closer inspection of what she had actually protected and who had benefited. Each defensive gesture became an additional exhibit, expanding the scope of review rather than narrowing it. In systems built on law, panic is expensive. Insurance carriers were the first to respond with clarity, because they always are. Once notified of potential civil rights violations and personal liability exposure, their questions cut straight through rhetoric. Coverage depends on lawful conduct, not intention, and the moment Karen's actions crossed into unlawful detention, the shield she thought existed began to dissolve. Board members received notices that were polite in tone and devastating in content, explaining exactly how much personal exposure they faced if they continued to support or conceal misconduct. Fear changed sides quickly. Experts stepped in next, not with spectacle, but with audits, reviews, and requests that demanded precise answers. Policies were compared against statutes. Meeting minutes were read against footage. Emails were examined for instruction rather than discussion. The gap between what Karen claimed and what the record showed widened with each pass. Retaliation doesn't play well in environments designed to measure consistency, and Karen's behavior had always relied on people not looking too closely. The board attempted damage control, issuing statements that carefully avoided naming her while still acknowledging procedural missteps. That distancing was not subtle. People who had once echoed her language now spoke in neutral tones, focused on preservation rather than loyalty. The structure she built to amplify her authority began to retract, segment by segment, as self-interest replaced obedience. Systems don't collapse all at once. They withdraw support until the center is left standing alone. Karen noticed the isolation before she admitted it, and her frustration bled into every communication. She accused, she implied conspiracies, she suggested bias, anything that allowed her to avoid the central issue. None of it mattered. Expert review is indifferent to emotion, and once the questions become technical enough, personality disappears from relevance. What remains is conduct, sequence, and impact. By the time formal recommendations were drafted, her narrative no longer appeared anywhere in them. Retaliation had been her instinctive answer to resistance for years, and it had always worked because resistance rarely came with expertise. This time it did. Each retaliatory act accelerated the consequences she hoped to avoid, drawing in additional oversight and solidifying conclusions that could not be walked back. She wasn't being targeted, she was being processed. The difference between those two things is where power actually lives, and by the time she realized that, the process was already far beyond her reach. The end did not announce itself with raised voices or dramatic declarations, because real endings rarely do. It arrived quietly, wrapped in paperwork and procedure, the kind of conclusion that feels almost anticlimactic if you don't understand how much weight silence can carry. The HOA did not fight to survive once the reality of exposure set in. Survival requires belief, and belief had drained out of the room weeks earlier. Resignations came in one by one, written carefully, stripped of loyalty and emotion, each board member choosing distance over defense. The structure that once amplified Karen's authority dissolved not with resistance, but with compliance, because compliance was the only language left that could reduce damage. Refunds followed, not framed as apologies, but as corrections. Fines that had once felt immovable vanished from ledgers as if they had never existed, quietly acknowledged as indefensible. Notices were rescinded, records amended. The mechanisms Karen had used to intimidate people were dismantled by the same processes she once hid behind, and no one rushed to stop it. There was no rally, no last stand, no attempt to preserve her position, because positions only matter when someone is willing to occupy them. By the time the final documents were filed, her name was absent from everything that mattered. The neighborhood changed without ceremony. Flags returned to porches that had stood bare for years. People walked where they wanted, when they wanted, without scanning for enforcement or calculating risk. Conversations happened again in open spaces instead of behind closed doors. The absence of Karen's presence was not celebrated. It was simply noticed as relief, the way you notice when a constant noise finally stops. Power that relies on fear leaves a vacuum when it's gone, but this one filled itself quickly with something simpler and steadier. Karen herself did not rage or protest publicly. There were no statements, no interviews, no attempts to reclaim the narrative she once controlled so easily. She passed through the community like a shadow that no longer registered, seen but not acknowledged, present but irrelevant. The authority she believed defined her had evaporated, and without it, there was nothing left to project. She discovered what all abusers eventually do when their tools are taken away, that without leverage, confidence has nowhere to stand. I did not give a speech, and I did not attend any ceremony marking the HOA's end. There was nothing to commemorate. The goal had never been triumph, only correction. My daughter went back to jogging without escorts, without fear, without the need to explain herself to anyone. That was the only outcome that mattered. The law had done what it does best when allowed to function. Not loudly, not emotionally, but thoroughly. The last time I saw Karen, she stood alone at the edge of a parking lot, phone in hand, waiting for someone who never arrived. No one confronted her. No one needed to. She had already lost the only thing she valued, the ability to make people react to her. The neighborhood moved on around her, indifferent and unbothered, and she finally understood what real power looks like when it leaves. HOA Karen went silent.